We have three primary avenues. The first is through direct testimony, the second is through in-camera interviews, and finally through third parties. Those comport with recent studies that have found that divorcing parents are often unable to clearly understand and consider their children's best interests and needs, and rather project their own needs onto their children. At no point in this meeting with the child is the mediator asking, what is the child's preference? Who does the child want to live with? And this is the idea of a voice, not a choice. So we're asking for the child to have a voice in these proceedings, not for them to choose which parent that they want to live with.
Welcome and thank you for joining us for another Justia webinar. My name is Nina and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speaker for today, Stephanie Tang. Professor Stephanie L. Tang is an associate professor of law at Baylor Law School. Professor Tang teaches family law, advanced family law, children and the law, and LARC 3, persuasive communication. Professor Tang is also the director of the Baylor Law Family Law Clinic. Prior to joining Baylor, Professor Tang was a partner at a family law firm in Chicago, where she specialized in all areas of family law. She obtained multiple certifications as a mediator, fellow with the Collaborative Divorce in Illinois, and certified financial litigator with the American Academy for Certified Financial Litigators. She has extensive experience with litigating, mediating, and collaborating on high conflict divorce and parentage cases. The webinar that you're about to watch will be approximately 1 hour, and Stephanie will be taking questions from the audience at the end, time permitting. So if you have questions, you can always submit those by clicking to the Q&A button in the control panel at the bottom of your screen and sending them in there. We will be taking those at the end of the presentation. Now, without further ado, here is Stephanie to discuss balancing children's role in custody mediation.
Thank you so much, Nina, for the introduction and for inviting me to speak here today. I'm going to go ahead and share my PowerPoint here. Thank you all for attending. And I'm really excited to talk on this topic in particular for Justia. I was asked by the American Bar Association Family Law Quarterly to write an article for their Family Law in the 21st Century issue, which was published last year. There were two volumes, and my article was published in the fall 2025 edition. So in addition to the bio that Nina just provided for us, as part of my role as a partner at a family law firm in Chicago, I had extensive experience mediating child custody cases as well. So this topic was pretty near and dear to my heart in terms of looking at the role of children in custody mediation, or should I say the lack thereof. So in my experience as a mediator, I often did not even question whether to involve children in mediation or not. It was always between the parents. That's what I was taught. That's how public and private mediations worked in Chicago. And so I always thought that the children were just not supposed to be in the mediation room physically, or their perspectives were also not supposed to be shared in the mediation room. And so what I want to clarify in talking through this topic today is that I'm not proposing that children sit down at the mediation table, um, but rather that their voices are heard as part of the mediation process, and they are included within the mediation process in a very deliberate way, as opposed to right now when often we are deferring to the parents and their determinations with regards to the children's best interests without regard to how children are perceiving the agreements that are being made on their behalf that impact their daily lives. So, to begin, I want to talk about the existing avenues for child participation in custody cases right now. So, those of you who are family law attorneys are very familiar with regards to the existing avenues for child participation in custody cases. And so, we have three primary avenues. The first is through direct testimony, the second is through in-camera interviews, and finally through third parties, such as a guardian ad litem, attorney ad litem, child representative, or child custody evaluator. So I'll take these in turn. The first, with regards to direct testimony, is fairly straightforward. So this often happens when the case gets to a contested hearing or a trial and a child is called to take the stand or to sit in a separate room and testify via closed circuit TV before the judge, their parents, and if they have them, their attorneys. This is often considered the most potentially traumatic avenue for children because they are exposed to their parents. They have to face them while they talk about their preferences of who they want to live with. They are asked questions in a very adversarial format. It's very seen as very overwhelming, and many of the studies find that it is overwhelming for many children, depending on their age and maturity, to testify in court. And this avenue as well, again, is often after the case has already gone past the point of reconciliation. Their parents are highly adversarial to each other and it's highly contested, either on a temporary custody or more often a final trial. The second avenue is an in-camera interview with a judge. In most states, this is discretionary. I believe in a couple, like Ohio and Texas, where I currently teach, there's a mandatory requirement to confer and interview children for judges if a parent seeks that type of interview. So, for example, in Texas, under the Texas Family Code 153009, if a parent has a child who is over the age of 12, then it is mandatory for the court to have an in-camera interview with that child. It is up to the discretion of the court if the child is under 12. So it is, and that's a minority approach. The majority of states leave this purely up to the discretion of the judge, or through the statutory means, or just completely silent in their statutes with regards to in-camera interviews and how those should be conducted with a child. So in the states that have no statutory guidance on in-camera interviews, often this is a purely through the means of a motion or motion brought to in front of the court. It's up to the judge's discretion as to whether to grant it. It's up to the judge's discretion as to what types of policies and procedures are implemented with regards to in-camera interviews. So this could include limiting the questions that are asked during that in-camera interview to questions that are submitted by the parties' respective attorneys. This could include having a court reporter present to record and take down everything the child says and providing that transcript to the parents and their attorneys afterward, and a host of other accommodations with regards to that interview process. Finally, the other common avenue is through a third party. And so, again, usually through an appointment of a guardian ad litem, attorney ad litem, or child representative, or a child custody evaluator. So the guardian ad litem, attorney ad litem, or child representative, those roles vary in terms of what states that they are involved in as well. Where I am in Texas, guardian ad litems and attorney ad litems are separate but often appointed in the dual role, where the guardian ad litem represents the child's best interests and the attorney ad litem represents the child's preference up until the point when they have a conflict of interest, in which case the attorney ad litem asks for a separate appointment of a guardian ad litem. In Illinois, where I used to practice, we had guardian ad litems and child representatives, and those varied in terms of their ability as in court and what they could and could not do in terms of asking questions and in their preparation of the reports that were submitted to the judge. The child custody evaluator, again, as many of you know who practice family law, is a expert role where often they're appointed by the court or as independent experts to interview the child. And after most likely thousands of dollars, they provide a report to the court with their recommendations based on the interviews with the children, the parents, learning all the history, any collateral witnesses, and so forth. So with each of these avenues, my article contends that the biggest issue with these avenues as they exist currently in child custody cases is timing. So for each of these avenues, as I mentioned with regards to direct testimony, this is and the other two are also often when mediation fails. Settlement has failed with outside of court, and now the parties are entering into contested litigation. We often are involving children in considering their voices only then, as I argue, after the mediation process rather than before. Even with the appointments of guardian ad litems, even sometimes they're appointed earlier than that, but often in practice, they're appointed for because they require additional fees after mediation has completed and later on in the case, after several rounds of negotiation have already occurred between the parties. And so, what I am proposing is an earlier intervention in terms of consideration of a child's voice and child's perspective. So, in talking this through, I think it's important to first talk through what the history of children's involvement in child custody mediation actually looked like. So, historically, it was believed to be in the child's best interest to shelter them from the chaos of their parents' divorce. This was based on the presumption that parents act in the best interest of their children, that children are incapable of rational decision making that serves their best interest, and that recent research contradicted this method of silence. And so now recent research has contradicted this method of silencing children in family law matters and has indicated that excluding children may actually lead them to feel loss, frustration, or injustice. Further, the research has shown that excluding children from mediation and other aspects of child custody proceedings overall may be inconsistent with their life experience, particularly for those parents who have adopted a permissive or authoritative parenting style. So, specifically, permissive parents often follow their children's wishes, their choices, and so children will likely feel anxious or reject decisions made without consulting them. Similarly, authoritative parents believe children should have a voice in decisions while not being responsible in that process. While not being held responsible in that process. So, with regards to the historical trends and the data, there has been a significant trend towards children's voices being included and heard within the divorce and child custody context. So, the drive behind this paper is to challenge the widely accepted practice of not involving children until much later in the process. In terms of doing research for this paper, what I found is that states are currently all over the place and are very vague if they do even mention children in their statutory guidance or local court rules with regards to the mediation process. A couple of examples here to kind of illuminate the spectrum of existing regulations on this topic. In Oregon, we have Oregon Statute 107785, which provides that mediation should exclude all individuals except mediation services personnel, the parties, their counsel, and the children of the parties. So here there's an indication that an intent by the legislature that children should have some involvement in the mediation process, but it provides no real guidance as to when children should be involved in the process, at what point they should be involved in the mediation process, whether it's before or once the parents have already gone through mediation and reached some preliminary agreements before signing a full mediated settlement agreement, or any other guidance as to what level of participation children should have. So, should their preferences be solicited? Should they just be consulted with regards to how certain outcomes might impact their daily lives and mental health and so forth? Similarly, California has California Family Code 3180, which provides that mediators have a duty to assess the needs and interests of the child. The mediators are entitled to interview the child when the mediator considers the interview appropriate or necessary. So here there's a little bit more guidance where it says now the mediator is the one considering the interview, whether the interview is appropriate or necessary in terms of involving the child. So the mediators are assessing the needs and interests and then considering interviewing the child if appropriate or necessary. So that is up to the mediator, it seems, under the California statutory scheme to determine whether children should be involved in the mediation process itself. In contrast, in Iowa, we have Iowa Code 59841, which provides a court may require the child's participation in the mediation insofar as the court determines the child's participation is advisable. So, unlike California, where it says a mediator is assessing the interests of the child, the Iowa statute indicates that this should be the role of the court to determine whether a child should be involved in the mediation process, and even go so far to say should require the child to participate in the mediation process. So it seems like the court, it almost appears sua sponte may require the child's participation in the mediation with even without a motion of the parties, based on the language of the statute. And again, does not give guidance as to when or what circumstances should be when that would be appropriate, what factors to consider, and so forth. Pennsylvania then talks about the parties themselves and the role of the parents in these mediation cases. So we already talked about the mediator deciding, we talked about the court deciding involvement of the children, and now we're looking at the parents' involvement and consent. So Pennsylvania Civil Procedure Rule of Civil Procedure 1940.5 provides with the consent of the parties, the mediator may meet with the parties' children or invite other persons to participate in the mediation. So here again, it's not a compulsion of the court. It's not a decision by the mediator, but rather if the parties so choose to consent, the mediator may meet with the parties' children or invite other persons to participate in that mediation. So now it's up to the parents, it seems like, to decide whether their children participate or not. So this takes me to my former jurisdiction, which was Cook County in Illinois, where the local court rules are actually pretty uh, involved in terms of family court services and public mediation. And so it provides that parents are given two 2.5-hour appointments to complete mediation. As part of the second mediation appointment, mediators may interview children between the ages of 5 to 17. Family Court Services uses a child focused mediation model through which parents are empowered to focus on future co parenting and the impact of their decision making on their children. Children are interviewed separately from their parents, and their interviews are also confidential and privileged. Children do not take part in the decision making process. They are interviewed only to ascertain their understanding of and adjustment to their family's new reality in the hope that parents will consider their needs when making decisions regarding their future. So here we have a question with regards to and some additional insight as to the purpose of the interview process, saying that children are interviewed only to ascertain their understanding of and adjustment to their family's new reality in the hope that parents will consider their needs when making decisions regarding their future. So this says specifically and gives some guidance as to the mediation, saying that children are interviewed separately from their parents and their interviews are also confidential and privileged. Um, so as opposed to, and they make explicit that it's not the children are involved in the room. Children are not involved in part of the mediation process itself, but rather they are interviewed separately, and the mediator determines what their understanding of and adjustment to some of the issues that are discussed in mediation might look like. Cook County goes on their website to describe the benefits of interviewing children, and they cite three primary benefits here. So first, allowing a mediator to provide feedback to the parents about the children's perceived needs. Second, a validation of the children's feelings. And then finally, assisting parents in moving beyond an impasse to create a durable child-centered agreement. So here, Cook County, which is where Chicago resides, but is also quite large. So Chicago and all of the contiguous cities um, allow a mediator to provide feedback to the parents about the children's perceived needs. This idea is that the mediator is interviewing the children first and then provides that feedback within the mediation session to the parents with regards to their child's needs. Validation of the children's feelings. So the idea here is that once the child's needs are assessed by the mediator, they can feel like they are validated in some capacity through these discussions between their parents. And finally, assisting parents in moving beyond impasse to create a durable child centered agreement. Here, the idea is that we can move beyond uh, any if there are conflicts that arise between the parents and they are not able to reach an agreement between themselves, we can try to have them discuss with base child perspective in mind, and to try to move the needle one way or the other. Okay, so some variables impacting involvement of children in custody mediation. I can see that there may be a lot of resistance to having children and feedback provided within the mediation session. Certainly, like I said, as a mediator myself, I can see that there are a lot of concerns with regards to interviewing children, particularly lack of qualification, lack of time, lack of money. So we'll talk about qualifications a little bit later in this, but I'll talk about kind of the time, money aspect, and then just the overall cultural considerations. So, with regards to the time aspect, obviously, interviewing children separately takes time. Oftentimes, a lot of the times, even the state provided mediations, I know that we were on a multiple month delay of the mediation process from the state. And so here, a lot of the times, this adding that mediation interview of a child could add even more time to the delays to public mediation. Money, obviously, things always come down to money. Mediation costs money, in especially or at least private mediation costs money. Having additional time with the mediator to meet with their children would likely also cost additional money. And so that weighs potentially against having the resources to involve children in mediation. And then finally, I mentioned culture, and I don't just mean culture in the sense of parenting cultures and styles. I mentioned earlier that sometimes if children are not really used to being involved in the decision-making process, it may be unnatural for their parents to now start involving them in that mediation process. But uh, broadly than that is the culture surrounding mediation generally in each of these jurisdictions. So, as I mentioned, in Chicago, it was common practice to not interview children as part of the mediation process. If everyone excludes children, then there's pushback for inclusion because that's going to mean that everyone's going to have to change how they do mediation. It's going to be an additional burden. They likely will have to obtain additional qualifications to not traumatize children in this process. Um, some mediators view advocacy on behalf of children as part of their role, and some do not. So, those who do view that as part of their role would be more likely to involve children and want to involve children in the mediation process. Um, and so those comport with recent studies that have found that divorcing parents are often unable to clearly understand and consider their children's best interests and needs and rather project their own needs onto their children. But other mediators may see that their role is to work with the parents and not to have the children feel like they are asked to be taking sides or anything within the mediation process itself. And so that takes me to the underlying model that I based my recommendation on within my paper. And so, um, for those of you who are interested in reading the full paper, they are included in the materials for this CLE through the Justia website, or you can email me for a copy as well. It's also available on the American Bar Association website. I based my proposal on the child inclusive mediation model that was first conceived of by Dr. Jennifer McIntosh and a group of Australian scholars back in the early 2000s. In this model, the child inclusive mediation involves a trained child consultant who meets with a child to discuss their experiences regarding the current family situation and their hopes, wishes, and fears. The consultant then follows this meeting up with a discussion with parents and the mediator to confer about the child's developmental needs, adjustment, and implications for drafting parenting plans. Dr. McIntosh's study found that agreements reached through this model were significantly more durable and workable than those who did not. Specifically, the studies found that parents who underwent child inclusive mediation were half as likely to initiate new litigation over parenting issues in the year following mediation than those who underwent what is they refer to as child-focused mediation. So child-focused mediation, in comparison, was where the mediator focused the parents on developing parenting plans that incorporated key psychological dimensions of adjustment by evoking a child's focus in the dialogue with the parents. So even that, in comparison to a mediator focusing the mediation on the child, Dr. McIntosh found that the parents who underwent child inclusive mediation were half as likely to initiate new litigation over parenting issues in that following year. It seems to follow and be a reasonable inference that if they were comparing those undergoing child inclusive mediation compared to mediation, where we don't consider the focus on the children, that uh, rate would be even higher. So, Dr. McIntosh, as part of her study, also solicited feedback from the parents and the children with regards to this model as a narrative explanation and reasoning behind their experiences with child inclusive mediation. So first, um, good quote from the parent's perspective said, "I heard the children's opinions, which were an eye opener. It gave insight into what they were going through. I do stuff differently now, and getting past the hurt and seeing them more clearly is what happened." From the child's perspective, we have that child inclusive mediation informs, reassures, and respects them, which has led in many cases to improved relationships between young people and their parents. So, what does this child inclusive mediation model look like? Step one is to select the child inclusive mediation process. Step two, to retain a separate child consultant. Step three, a pre mediation session meeting with parents. And then finally, steps 4 and 5, meetings with the child and feedback conversations. So, with regards to step one, selecting the child inclusive mediation process first, usually, family courts are unaware of child inclusive mediation as an option, so they just accept what is offered. The mediator typically provides resources after the initial screening and lets the parties and the judges know that child inclusive mediation is an option. So, where this is practiced, I found kind of more readily in practice is in Minnesota. And so I interviewed a few of the child inclusive mediation mediators up in Minnesota to kind of talk through what this education process looks like to the judges to make sure that they are aware that child inclusive mediation is separate and as a kind of a variation to traditional mediation. It's not for everyone and not for every case, but uh, it may be very appropriate in certain cases, as we'll talk about. Step two is the retention of a separate child consultant. So, in the initial conception of the child inclusive mediation model that Dr. McIntosh proposes, she proposes a retention of a separate child consultant in these cases. So, you're retaining a separate person. There are arguments that adding another individual further dilutes a child's voice in the mediation process. But Dr. McIntosh counters these arguments by saying the reason for obtaining a separate child consultant rather than using the same mediator is because research found parents express a greater readiness to listen to their children's views that are contrary to their own when these views were conveyed empathetically by an independent specialist. Step three, pre-mediation session meetings with parents. So a child consultant talks to each parent before the mediation to obtain information regarding the parent's perspective about the child, including any behavioral considerations or special needs. So again, the first step is still meeting with the parents. This is similar to what we as mediators do, where we have intake packets with the parents, have them fill them out, have a pre-mediation session with parents to talk about behavioral considerations and special needs of the children. Next, with regards to meeting with the child, so I want to clarify that this is a needs, not a preferences meeting. Just like we are focusing on needs and interests for the parents, we're focusing on needs and interests for children as well. So here, you're setting up, you can set up meetings with the children together if they are siblings, and then separately. Typically, from talking to mediators who practice child inclusive mediation, this is typically separated into two different meetings. So the first meeting is asking some key questions. First, you review confidentiality with the children. Then you talk, draw, play with the child using assessment methods adapted to the child's age, comfort, and communication. So you're focusing on three main questions in this first meeting with the child. The first is, what is it like to be the child now that their parents have decided not to live together? Second, what is it like to be this child being dependent on each parent? And finally, given the family context, what might help them to feel more secure and supported? So you'll note that at no point in this meeting with the child is the mediator asking, what is the child's preference? Who does the child want to live with? And this is the idea of a voice, not a choice. So we're asking for the child to have a voice in these proceedings, not for them to choose which parent that they want to live with. And so often we have uh, the asking the child to identify again how they're currently feeling now that their parents have separated. What is their experience like so that they can express what their experience has been like since their parents have started this divorce proceeding, or in the case of a parentage case, since they've initiated this custody proceeding. The second meeting is reviewing a summary of that first interview and asking two questions of the child. First, did I get the summary right? And second, can I relay this information to your parents? So, as I mentioned before, the first meeting starts with that review of confidentiality with a child and saying that this information is not going to be shared with the parent unless the child specifically authorizes them to do so. So, with regards to this, um, we are ensuring that whatever is discussed in that first session is accurately depicted by that mediator. It provides a safeguard and kind of check on the mediator's first meeting with the child, say, um, if things were kind of unclear or ambiguous on the first meeting, it provides the child a way to clarify what the mediator had initially garnered in their summary from the first meeting. And then the second, can I relay this information to the parents? So now the child feels like they have some control in terms of what information is ultimately spread to the parents. They feel like they are not being forced to share everything with their parents. If there's something that they're not comfortable sharing, they have that ability to do so as well. So, talking to the child inclusive mediator, in mediation um, practitioners in Minnesota, one thing that they use is these bear cards. And so these are the 48 bears. They encapsulate a wide variety of emotions and can help children who are having a hard time articulating what emotions that they are feeling express to the mediator what those emotions look like. Um, so if you want to take a look here and see how you're feeling today, this morning I was feeling particularly 46. Now I'm at a nice 1. I'm happy to be here. I'm excited to share this paper with you. But definitely rushing around this morning. It's hat day, silly hat day. For those of you who have tiny children doing Read Across America. So there's a lot of panic going on there. And so these um, using these types of tools in these meetings with children help children think through what and articulate and identify the feelings that they're currently feeling to the mediator when they are otherwise they don't know. Divorce is a complicated process. Child custody proceedings are complicated in and of themselves. They're having a lot thrown at them, and they have a lot of emotions to untangle. So they might be feeling a wide variety of different emotions at the same time. So they might select a few different cards. The mediator can talk to them about that and kind of prompt them based on the card that they select. To determine and really hone in on what is causing those feelings. Has it been post separation, or have these feelings been going on for a while, and so forth. Okay. So with regards to, I'm sorry, I'm gonna go back. Um, Step 5, we have our feedback conversation. So this is the final step in the child inclusive mediation context, as initially conceptualized by Jennifer McIntosh. And so In these feedback conversations, the child consultant begins the session by describing the family through the eyes of the children. They give feedback from the child's perspective, and the mediator asks clarifying questions and checks in with the parents and develop an agenda for the mediation session with the parents based on the child's feedback, and based on this description of the family through the lens of the children. Okay, so my proposed framework is similar to Dr. Jennifer McIntosh's with a slight variation and has some variation built into it, again, acknowledging that there is going to be pushback on this model overall by many attorneys and mediators who practice mediation without involving children in any capacity, whether it is without interviewing them, without involving them, and having them have a seat at the table, literally, or what have you. So, within this proposed framework, I focus on three different perspective and roles. So the first is the role of the mediator. The second is the role of children and who should be subject to this type of mediation. And finally, the role of the parents. So we'll start with the mediator first. So the mediator, under my proposal, is the same person who interviews the children and provides feedback to the parents. The mediator is a mental health professional or lawyer with credentials who is experienced, comfortable, and knowledgeable in treating children with separated parents. So here you'll notice off the bat, I do not recommend for hiring of a separate child specialist, and rather I am deviating from Dr. McIntosh's original model and instead following one where the mediator and child specialist are one and the same. And this is the model that's followed by the United Kingdom for child inclusive mediation, where one person serves as both the mediator and the child consultant. I propose that this avoids additional dilution. It allows the mediator to have the necessary context regarding parents firsthand from the child when conducting the mediation, as opposed to relying on the child consultant to do so and then reporting its secondhand to the mediator. The mediator then does not have to rely upon this feedback session that I just described, where the child consultant kind of talks about the issues from the child's perspective. Rather, they can be the ones who have control over that feedback session. In this, I did want to caveat that I do think that this requires some additional qualifications of mediators who engage in child inclusive mediation before they can actually move forward with effectively engaging in this model. Without these qualifications, interviewing children and attempting to relay their views to parents could prove quite harmful to children. So specifically, ideally, a mediator should obtain a professional certification in psychological, clinical work, or clinical social work or family therapy with substantial training in development, attachment, trauma, and family systems theories, and experience in the clinical application of those theories. Ideally, the mediator should have experience treating children of separate parents, not just children generally as well. Recognizing that you're busy attorneys. Mediators are busy, and sometimes they don't have those qualifications already. For those mediators who are not attorney mediators, my variation on this is talking through an alternative. So the mediator is uncomfortable or feels like they are not trained to act in both roles. Then the alternative is going back to Dr. McIntosh's initial child inclusive mediation model, where they engage a separate child consultant or an experienced co-mediator to meet with the children. So here now we have the idea, as I just articulated to you all, that we have a separate child consultant with these qualifications. The mediator finds someone who can act as a child consultant and talk to the children about their needs and interests, and then provide a feedback session before the mediation session happens with the parents. That takes us to the role of the children. So the children in these cases, again, each child needs to be treated separately. Just like in a child custody proceeding where you're determining the needs of and best interests of each child separate from their siblings. This is the same for child inclusive mediation as well, and this model. So here, each child consents to provide input and is of sufficient age and maturity with mental capacity to provide their input in the mediation process. So again, I want to emphasize that we are not looking at the idea of the child who it does not have the ability to articulate their voice and have a voice in these proceedings because they cannot verbalize their feelings or identify those feelings. I will say that I want to focus more on maturity determinations as opposed to age determinations because, as we all know, as practitioners, the age of the child, you could have a very mature 6-year-old, you could have a 6-year-old who's pretty nonverbal. And so, looking at the maturity of the child to provide and with mental capacity to provide their input in the mediation process. Alternatives here, looking at child-focused mediation, that's something that I had discussed, at the beginning of, this talk with regards to, as a reminder, the mediator focusing the parent on developing parenting plans that incorporate psychological dimensions of adjustment or evoking a child focus in dialogue with their parents. So, how do you think the child would feel about this as if a means of reality testing, um, as opposed to just asking and trying to make sure the parents' needs and interests are met? Second option, consulting with a child's therapist, obviously subject to any relevant state confidentiality provisions or laws, any HIPAA requirements, and so forth. Um, but with regards to overall how the child is feeling, as opposed to their underlying, um, what is actually said in the therapy sessions, can be helpful. And then finally, we go back to our in-court avenues for child input and seeing whether they can be done before we get to a contested hearing or a trial. So I mentioned at the very beginning of this talk, our three avenues of direct testimony, in-camera interviews, and appointment of guardian ad litem or attorney ad litem or child representatives or whatever your jurisdiction refers to those roles as. And what I mentioned that I found troubling about all of these interventions is that they all occurred after multiple rounds of negotiation. And so here, um, I recommend that if we do want to involve children or let them have a voice in these custody proceedings, that we can have a appointment of a guardian ad litem pre-mediation to represent the child's interests, or have an in-camera interview with the child before that the parents have access to the transcript for example, before we hit a temporary custody hearing and the judge can consider in making their ultimate rulings on custody determinations, whether it's a temporary or a final determination in a particular case. So the next aspect is looking at parents. So first, if the parents do not agree to give appropriate weight to their children's input, likely they are not appropriate a for a child inclusive mediation model. And so when you are looking at this, the first consideration is whether the parents agree to mediation and agree to give the appropriate weight to children's input. So not just agreement to mediation itself and the process itself, but whether the parents agree to give the child's input weight within the mediation process. So usually in assessing this, what the mediators who I interviewed relayed to me said that they will generally ask two questions. What uh, Ask what the parents want out of the mediation process, and second, how they would react if the mediator relayed that the child said they wanted to primarily reside with the other parent. Again, this is not something that's actually asked of them. We're just assessing what the parent's reaction would be. The answers to these questions can help a mediator determine whether the case is one where both parents and the children would benefit from hearing from a child in the first place. If a parent answers, then if the child said they wanted to primarily reside with the other parent, then they are lying to you, or answer something like, I would know the other parent is manipulating them in that circumstance. That would be a red flag that this model is not appropriate for that particular family. If they are not willing to give appropriate weight to their children's input and they automatically assume bad actions on behalf of the other parent, likely they are not a good fit for this mediation model And so it does take a little bit more pre-work on the mediator's side in engaging in this. So in this process. Second, with regards to the parents, ideally that there's no history of intimate partner violence between the parents. Um, this is very similar to our screenings right now for mediation. Oftentimes, if there is prior family violence or history of prior family violence, then the parents are not uh, there might be a red flag. The parents are not suitable for mediation generally. So similar concepts apply here, where if there is a history of intimate partner violence between the parents, it is likely going to be a red flag for involvement of the parents generally. And then finally, I contend that the status of all legal parents of the children subject to the proceeding should already be adjudicated before the proceedings are before mediation starts and before child inclusive mediation is commenced. So, what I mean by this is that if there is a question as to whether a individual is a child's legal parent or not, that parent's determination should be decided first before going into the actual mediation process. So here, alternatives here, again, if the parents do not agree to give appropriate weight to the children's input, then it's likely this model is not appropriate for that family, and we should explore some other options like the ones I mentioned before, including child-focused mediation, consultation with the child's therapist, or in-court avenues for child's input. If there's evidence of prior intimate partner violence, then you can try to determine whether any concerns regarding proceeding with a mediation due to prior family violence may be remediated through adopting appropriate safeguards or process modifications, including necessary protections for children. Um, Here we can look at again if there are any possibilities to remediate the prior family violence through appropriate safeguards, or again, whether it is going to preclude the parties from effectively having a child inclusive mediation model. Finally, if the state recognizes more than two parents and or if parent which is at issue and has not been adjudicated, then courts should first make a ruling regarding parentage status of any individuals seeking to be adjudicated as a child's parent and then proceed with the mediation. So again, parentage determination first, then the moving forward with the mediation itself. So on that, there's an example through in the California courts where there are multiple parents who are involved. Um, California is a state that does recognize more than two legal parents, so that is also a consideration here. In this case of called CA versus CP, I have the citation here for you. The court first found the child's stepfather was a presumed parent entitled to share in custody of the child, and then ordered all three parents to attend mediation. So instead of just having two parents involved in the mediation, the court made that determination of who is actually a legal parent first, and then ordered all of the parents to um, attend mediation to have that discussion with regards to these custody issues, including decision-making responsibilities and parenting time. Um, Sorry, one more thing on this. This also might include states that recognize functional parenthood. Um, so if there's a state that recognizes some form of functional parenthood that might be in loco parentis or de facto parentage, um, or whatever the the parallel term is called in your jurisdiction, this would be another consideration as well to determine the legal status of parentage of a de facto or other functional parent before proceeding with the mediation process. Um, Generally speaking, with the de facto parent determination, we may have a separate hearing that is looking at various factors to determine whether there's a de facto parent or not. And then once that de facto parent is determined, then there's a question within the jurisdiction of whether that de facto parent actually assumes all the rights and responsibilities of legal parents, or whether that they have some limited ability to seek um, custody or visitation within the mediation context, and I think that's important as well. So in some states, um, de facto parents, once they're adjudicated, still are limited to only visitation rights as opposed to full custody rights. And so in those cases, again, it will impact the way the mediation moves forward. So I think that all of those issues should be adjudicated prior to the mediation uh, s the mediation starting. One thing to talk through in terms of the red flags that might come from intimate partner violence, is this SAFER approach. So the SAFER approach was developed by Gabrielle Davis, Loretta Frederick, and Nancy Versteeg. Um And in this approach, the mediator will first decide whether the history of the domestic violence impacts the parent's ability to effectively mediate a dispute. And if there are concerns, then the mediator will explore again whether the concerns may be remediated through process modifications or adopt appropriate safeguards. So, SAFER, as conceptualized by these three scholars, stands for screening for domestic abuse, assessing the nature and context of the abuse, focusing on the effects of abuse, and then responding to abuse in actions and decisions. So, the idea here again is determining whether you can still move forward with child inclusive mediation despite not, despite there being prior history of intimate partner violence or, or something equivalent. So that takes me to my contact information here. Um, you can reach me at this email if you have any questions regarding anything I've said here today or the article itself, or want to talk about what this might look like generally in terms of the process and procedure. So I have about 12 minutes left for questions if you have any questions.
Awesome. Well, thank you so much, Stephanie, for sharing all of those insights with us. If you haven't yet had a chance to pop your question in the Q&A, you can do so by clicking the Q&A button in your control panel in Zoom and sending them in there. It looks like we already have a few, so I'll just kind of read them off and we can go through those. This first question is, when you consider involving children in this process, what is the age range where it's appropriate to do so? For an example, would a toddler be involved, a kindergartner? How do you gauge the role that age plays when it comes to these things?
Yeah, so I think it is more of a maturity question than an age question in most of these cases. And so we're looking at the child's mental capacity to articulate and answer some of these questions that I had mentioned in that initial meeting. So talking through specifically, again, whether they're able to answer those questions that I had talked through in that slide, specifically asking about how their parent separation has affected them. Um, what is it like to in their world now that their parents have decided not to live together? In interviewing the child inclusive mediators in Minnesota who practice this regularly, they did say that the lack of ability to articulate kind of more meaningfully is not necessarily a barrier to including children in the mediation process. They've had the children draw how they're feeling. It may not have as much weight in terms of the feedback session, but they've engaged in drawing or at play activities, pretend play, very similar to what a guardian ad litem or attorney ad litem does in a traditional litigation context. And so so that doesn't necessarily preclude a child from engaging, and I think that's up to, again, the mediator's discretion in terms of whether to involve one, both, or all children in the mediation process.
Awesome. Well, thank you for that insight, Stephanie. Definitely really helpful when looking when to implement these. So, this next question is: how do you feel some traditional methods of obtaining children's input, like camera interviews, evaluations, just testimony, fall short in some ways? What do you think can be improved upon, and that really this is filling the gap for?
Yeah, so as I said, I think timing is the biggest concern that I have with regards to those traditional methods. So the in-camera interviews, evaluations, etc. Most of them happen, as I mentioned, post mediation. Right now in practice, which means that parents are already kind of positioning themselves in terms of uh, considering options post the proceeding being done. And that seems to be too late for a child's voice to be considered in this process. It should be contemplated earlier on, as opposed to very far down the line when the parents are already kind of rooted in their positions. The other consideration there, if for example, why a guardian ad litem or an attorney ad litem being appointed pre-mediation would not just solve the problem, is that there's some cost considerations there. Obviously, once you have a guardian ad litem appointed, they take a retainer. And usually that retainer is significantly higher than what it would take to have the mediator interview a child for an hour or two in these two different feedback sessions. Um, and so I think that there's a cost consideration there. In terms of practical, aspects of the traditional methods as well, kind of going more towards the direct testimony or in-camera interviews, the judges have very limited time. Even in Chicago, and now I practice in Texas, we have significant delays in many dockets on these very high traffic, highly congested dockets where you can't even get a hearing date for many months out. And so if you're waiting for a judge to be able to have an in-camera interview with a child, it might also take that same amount of time. You really don't have that same, efficiency as you might see with the mediation process, which typically has a shorter, time frame moving forward. And then finally, with regards to qualifications, this is just another avenue of who needs to be qualified. So the judges obviously go through their judicial training, but they might not have specific training as it relates to children and interviewing children, and minimizing trauma to children. Or sometimes the judges are not, because it's left to the discretion of the judges, are not willing to do that. I've had several judges who I brought motions for in-camera interviews in front of, and they said, "I don't do that." And there's no real recourse because it's not statutorily included within the jurisdiction, that where in Illinois, where I practiced before, I could bring the motion up to the judge's discretion, and if they denied it, then there was really not much I could do after that.
Awesome. Well, thank you for that insight, Stephanie. This next question kind of relates to cost. So you touched on that a little bit, but this person's asking who bears the cost of these mediations and mediators. This is an Arizona attorney. They share in Arizona, we do not typically involve children directly in the process, but it's discretionary with the judge, as you were saying just now.
Yeah, so I think it depends on whether it's public or private mediation. If it's public mediation, so we have family court services here where the state bears the cost. Again, those typically have very long deadlines. If it's private mediation, usually the parties bear the cost. And so I think that also again impacts whether the model is appropriate or not based on those cost considerations. So it can just depend on the state in which the mediation is being practiced in. I know in Texas we have dispute resolution centers, and many states don't have that kind of equivalent of having a income qualifying resource for mediation as an alternative to the kind of fully state funded versus the private option.
Awesome. Thank you, Stephanie. This next question is: with the child inclusive method, what is the next step if the child tells the mediator they don't want to share the information with their parents? What would the mediator do in that situation?
Think that the mediator then, because we're trying to respect the child's wishes and needs in those cases, would just uh not share what the child doesn't want them to share. I think this is all about kind of making sure the child's kind of interests are are addressed and needs are met. to the extent that the child is willing, but we don't want to do that at the cost of jeopardizing and further traumatizing the child's relationship with their parents. And so if the child is not willing to share some aspect, I think the mediator can kind of tease that out a little bit more, say, is it anything within this topic that you're not willing for me to allow me to share? Or is it just this specific aspect or this specific incident or this specific feeling? Um, and I think in talking to those who practice child inclusive mediation, that was typically what their answer to me was then, is that they would try to see whether there are some limitations that we could have on the mediation process generally. Um, or sorry, in terms of on the information that the child was willing to share, not willing to share. And then if they were not willing to share, trying to, if they really were adamant that they did not want to share it, to respect the child in that regard, because the whole purpose of this is to try to get the child some additional voice in these proceedings. And so some information is still better than not having that information at all, in my opinion.
Absolutely. Thank you, Stephanie. And then kind of the flip side of that, when you have, maybe the child doesn't say that they don't want to share specific things, but you mentioned that, the parents' reactions may vary, right, to the information that's shared. So, how do you think is the best way to go about sharing the information that the mediator may get from the child with the parents?
Yeah, so what they typically do is they actually act as the child in these feedback sessions. So my understanding is that when they start the mediation process, they actually convey the information as if they are conveying it from the perspective of the child, as opposed to like, I talked to your child and I think that they said this. Say that you are conveying this information in the feedback sessions as if that they actually are the child themselves, and then having that be the way that they are best articulating it, and really, again, trying to give voice to the child themselves as opposed to try to speak on their behalf, which is, again, what we're all doing now. And that really would not make that much of a difference. You have to hear it from the voice of their child. Um, it might, if there are visuals, if they do engage in pretend play, if there are pictures that come with that, sometimes that comes into the feedback sessions as well. But again, that needs to be the first step in the mediation process before the agenda setting even occurs, where we have the kind of tone of the mediation is set to focus it on the children. And then once the children's perspective is articulated, then the parents can go from there and say, okay, now what are the things that we want to include on this agenda for the mediation today for us to discuss overall?
Awesome. Well, thank you, Stephanie. I think those are all of our questions, but do you have any final resources you'd like to share or any research? I know we had a question about different articles that they could look at, and we referenced a few that are, of course, in the materials that they can download. But are there any other resources that they can use kind of in perpetuity going forward for this kind of topic?
Yeah, so like I mentioned, the um original conception of the child inclusive mediation model was Dr. McIntosh's study. So I'd recommend looking at that. There are several additional books that have been published by scholars that are cited within the American Bar Association article that are included with in your materials, that I use um, pretty frequently. And then just interviewing people who engage in this process. That has honestly been the most helpful thing to me. I really appreciate the mediators who I talked to who practice child inclusive mediation in Minnesota, that I was able to talk to about what this actually looks like in practice. I think that's the biggest pushback that I've had from talking to mediators, is how do I actually adopt this? How do I practice it? And if you can talk to someone who actually does it, who has found this has not, significantly burdened their traditional practice of mediation, has not significantly changed how they practice mediation overall, then it's less of a lift and a little bit less daunting as well.
Awesome. Well, thank you so much for that helpful insight, Stephanie, and answering all of our audience questions. And thank you to all of our audience members who submitted questions. We always really appreciate your participation. We want to thank you all so much for joining us for another Justia webinar. Before you go, don't forget that Justia Connect Pro gives you access to CLE credit opportunities regardless of your jurisdiction and on the go with all of our on-demand webinars and select live webinars. So helping you stay informed and meet your requirements. Plus, Pro members also enjoy enhanced directory profiles, AI-powered Justia chat to help you capture more leads, and exclusive discounts on Justia marketing solutions. So to learn more or upgrade today, you can go to pro.justia.com. Thank you all so much for joining, and thank you again, Stephanie, for your time. Hope you all have a wonderful rest of your day. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.